If you are not a U.S. citizen and you have been inside the United States for more than 30 days, then starting June 29, 2026, a new DHS final rule is now in effect that could directly impact what documents you must carry, what proof you need to keep, and whether you are required to take action today. And the most dangerous part is that millions of people do not even know if they are already registered or not, which means one wrong assumption could put your entire immigration future at serious risk. So watch this entire video because we are going to break down exactly who is affected, what qualifies as proof, and what you must do right now. As of June 27, 2026, the Department of Homeland Security, through USCIS, has placed a final rule titled Alien Registration Form and Evidence of Registration on Public Inspection for publication in the Federal Register. USCIS stands for U.S. Citizenship and Immigration Services. DHS stands for the Department of Homeland Security. The rule is identified as taking effect on June 29, 2026. The same notice also invites public comments on potential future modifications until August 28, 2026. This means the final rule becomes effective on June 29th, but not every concept mentioned in the notice is finalized today. There was earlier litigation concerning the 2025 interim final rule. A federal court declined to block that earlier rule before it became effective. As of June 27, 2026, I did not locate a nationwide court order stopping this June 29th final rule. However, court proceedings can change quickly. If your decision depends on timing, please review official updates and consult qualified legal assistance. DHS explains that this rule does not create a completely new registration requirement separate from existing law. It establishes a general method for individuals who are already obligated to register but previously lacked a clear process. Let us review how the prior system functioned. The duty to register is not new. U.S. law has long required many non-citizens age 14 or older to register and provide fingerprints if they remain inside the United States for 30 days or longer. Non-citizen children under 14 may also need to be registered by a parent or legal guardian. When a non-citizen turns 14 inside the United States, there is a separate requirement to register again and be fingerprinted within 30 days after that birthday, unless fingerprints are waived. There is also a carry requirement. Many registered non-citizens age 18 or older must carry evidence of registration. In this context, evidence means documentation or proof. There is also an address reporting requirement. Many non-citizens must notify authorities of a new address within 10 days after moving. Before this new rule, many individuals were already considered registered because they received documentation during standard immigration procedures. A student or worker who entered the United States generally received an I-94. An I-94 is the arrival and departure record. It typically lists your admission category and the date until which you are authorized to stay. A visa stamp in your passport permits you to travel to a port of entry. The I-94 usually governs your authorized stay after admission. A green card holder has Form I-551, also known as the Permanent Resident Card. An individual with work authorization may hold Form I-766, called an Employment Authorization Document, or EAD. A person placed in immigration court proceedings may receive a Notice to Appear, which is Form I-862. These documents are important because DHS regulations list many of them as evidence of registration. The gap DHS identified was that certain individuals did not have a clear general form available to them. This could include someone who entered without inspection and was never registered through another process. It could include some Canadian visitors who entered at a land border and were not issued an I-94. It could include certain children who must register upon turning 14. DHS has now finalized the use of Form G-325R, titled Biographic Information Registration. Biographic refers to basic personal details. The form is submitted online through a USCIS account. USCIS reviews the information provided and available DHS records. Some individuals must attend a biometrics appointment. Biometrics refers to fingerprints, a photograph, and a signature. After completing the required steps, USCIS uploads a document called USCIS Proof of Alien G-325R registration to the person's online account. The individual can then download and print it. However, it is essential to understand a key limitation. Form G-325R does not grant lawful status. It does not provide work authorization. It does not issue a green card. It does not grant asylum, parole, TPS, or a visa. It is strictly a registration process. Consider a student named Daniel. This is only an example. Daniel entered the United States with an F-1 student visa. At the airport, CBP admitted him and generated an electronic I-94. CBP stands for Customs and Border Protection, the agency that processes individuals at ports of entry. Daniel sees social media posts claiming that every non-citizen must file G-325R. He becomes concerned. However, if Daniel has an I-94 from his admission, he may already possess evidence of registration. His first step should be to download his I-94, review the information, save a copy, and consult his school official if anything appears incorrect. This example demonstrates why the key question is not simply, do I file G-325R? The more helpful question is, am I already registered? And what proof do I currently have? Now let us look at who may be most directly affected. The group most immediately impacted includes non-citizens inside the United States who are required to register but do not already have listed proof. This may include some individuals who entered without inspection. It may include certain Canadian visitors who entered for business or tourism at a land port and remained 30 days or more without receiving an I-94. It may include children turning 14 inside the United States. It may include people with pending immigration filings who do not yet have an I-94, green card, EAD, court document, or other listed proof. Individuals who may be affected later include those with EADs and people with certain pending benefit requests, because DHS is currently requesting comments on possible future revisions. However, this does not mean the EAD loses its status today. Under the final rule taking effect, the EAD remains listed as evidence of registration. DHS is only requesting comments regarding potential future treatment. People who are likely not affected in the same way include U.S. citizens, green card holders who possess an I-551 card, many non-immigrants with an I-94, many individuals with an EAD, and people in removal proceedings who hold a notice to appear. Removal proceedings refer to an immigration court case in which the government asks a judge to order someone removed from the country. This rule mainly concerns registration duties inside the United States. A visa interview abroad is handled by the Department of State. Admission at the border is managed by CBP. Form G-325R is processed by USCIS. These agency distinctions matter because a visa stamp, an I-94, and a USCIS filing are not interchangeable. Now let us focus on the first crucial point. Proof of registration is not the same as lawful immigration status. This is where significant confusion occurs. A document may show that you registered, but it may not demonstrate that you are authorized to work. It may not confirm that you are allowed to remain permanently. It may not protect you from removal if you have a separate immigration issue. Why is this important? Because someone might submit G-325R, believing it is a new immigration benefit. That is not what the rule provides. Consider a parent named Anna. This is only an illustration. Anna entered the United States without inspection several years ago. She has a U.S. citizen child and hopes to resolve her status through family sponsorship in the future. She hears that G-325R is a new pathway to protection. That is a misunderstanding. Registration may help satisfy a registration obligation, but it does not create a family petition, a waiver, cancellation of removal, asylum, or a green card process. What is confirmed is that G-325R creates proof of registration after the required steps are completed. What remains uncertain is how DHS may later revise related proof rules for certain documents. A careful next step is to review your current records before filing anything. If you have unlawful entry, a prior removal order, criminal issues, or a pending humanitarian case, seek legal advice before acting. The second essential point concerns what qualifies as proof. This is the section many viewers should save and review carefully. Common proof may include Form I-94, I-94A, or I-94W for certain admitted or paroled non-citizens. It may include Form I-551, the green card. It may include Form I-766, the EAD. It may include Form I-862, the Notice to Appear, and Form I-863, the Notice of Referral to Immigration Judge. The final rule also adds Form I-860, called Notice and Order of Expedited Removal, and Form I-871, called Notice of Intent or Decision to Reinstate Prior Order, as evidence of registration for listed groups. These are serious enforcement documents. If you have one, it may qualify as proof of registration, but it does not resolve your removal matter. The rule also includes USCIS proof of Alien G-325R registration for individuals who complete that process in certain border or travel contexts. It includes the DSP 150B1/B2 visa and border crossing card for citizens of Mexico residing in Mexico. It also includes CBP-approved Trusted Traveler documents or electronic equivalents for Nexus, Sentry, FAST, and Global Entry when the individual was last admitted through that Trusted Traveler program. A valid, unexpired DHS admission or parole stamp in a foreign passport may also be relevant. Why is this important? Because many individuals already have a document that may qualify. Filing G-325R when you are already registered could create confusion rather than clarity. Consider a worker named Priya. This is only an example. Priya holds H-1B status and has an I-94. She also has prior immigration records from an earlier case. She sees a headline claiming that all EADs stopped qualifying under this final rule. That statement is inaccurate. The EAD remains listed now. A possible future change is only under discussion during the comment period. Priya should organize her I-94 and related documentation, not rush into filing based on a misleading post. What is confirmed is that these documents remain valid under the rule taking effect. What remains uncertain is whether DHS may revise certain proof rules after the new comment period. The practical step is straightforward. Create a proof folder. Save your I-94, green card, EAD, passport admission stamp, court notices, border crossing card, trusted traveler record, and any G-325R proof. Keep both digital and printed copies. If you are age 18 or older and required to carry proof, ensure you have a dependable way to present it. The third essential point is less obvious, but may affect your long-term immigration plans. Some individuals may have filed for an immigration benefit, but may not yet have clear proof of registration. A receipt notice confirms USCIS received a filing. It does not always mean the receipt itself qualifies as registration proof. For example, Form I-485 is the application to register permanent residence or adjust status. Adjustment of status refers to applying for a green card from within the United States. DHS acknowledges that certain benefit filings may collect registration information, but DHS is also requesting comments on how to issue evidence of registration before the related benefit is finally decided. This suggests there may be a documentation gap for some pending applicants. Consider the spouse of a U.S. citizen named Kareem. This is only an illustration. Kareem filed Form I-485. He has a receipt notice and a biometrics appointment notice. He does not yet have a green card or work authorization. He assumes the receipt notice automatically serves as proof of registration. That assumption may be incomplete. Kareem should confirm whether he has an I-94, whether he already holds another listed proof document, and whether legal guidance is appropriate before submitting anything additional. What is confirmed is that DHS is requesting comments about issuing evidence before certain benefit requests are decided. What remains uncertain is whether DHS will introduce a new proof system later. The responsible step is to preserve every receipt, biometrics notice, approval, I-94, EAD, and court document. Do not discard prior immigration records. Now let us connect this rule to everyday life. This is not only about a form number. It can affect school enrollment, employment verification, travel planning, family decisions, and overall peace of mind. A student may need to carry an I-94. A worker must understand that a visa stamp and an I-94 are different documents. A Canadian visitor may need to evaluate whether not having an I-94 creates a registration issue. A parent may need to act when a child turns 14. Here is a short example story. It is fictional. Maria is a green card holder. Her son Luis also has a green card. Luis received his card at a young age. The family is busy with school and work. Then Luis turns 14 inside the United States. Maria assumes the existing card is sufficient without further action. However, non-citizen children who turn 14 may have a separate registration and fingerprinting requirement. For a lawful permanent resident child, the family may need to review Form I-90 instructions instead of filing G-325R. Form I-90 is the application to replace permanent resident card. Careful planning can reduce stress, protect travel plans, and support future naturalization. Naturalization means applying to become a U.S. citizen after meeting legal requirements. Now let us discuss practical steps. First, identify your proof. Look for your I-94, I-94A, I-94W, green card, EAD, passport, admission or parole stamp, border crossing card, trusted traveler document, immigration court notice, or USCIS, proof of alien G-325R, registration. Second, review the information closely. Check your name, date of birth, A number if applicable, admission category, and entry details. If something appears incorrect, do not guess. Use official correction channels or seek assistance. Third, save copies. Keep a secure digital copy and a printed copy. DHS has indicated that electronic proof, such as an I-94 or G-325R document, can be printed, and the printed version may be laminated without invalidating it. Even so, phones can lose power and accounts can become inaccessible, so a printed copy can provide reassurance. Fourth, keep your address updated. Many non-citizens must report a change of address within 10 days of moving. Do not provide a false address. Do not list a location where you cannot receive mail. Missing an official notice can seriously damage a case. Fifth, never provide false information. Never hide material facts. Never fabricate dates. Never invent employment history. Never submit a form solely because an online post created fear. False statements can lead to serious immigration consequences. Now let us address 3 common misunderstandings. Some posts claim that every non-citizen must file Form G-325R on June 29th. That is incorrect. Many non-citizens are already registered or already possess proof. The real question is whether you are required to register and whether you already have listed evidence. Some posts claim that the EAD no longer qualifies as proof after June 29th. That is incorrect under the final rule taking effect. The EAD remains listed. DHS is requesting comments about possible future changes, but a request for comments is not a final rule. Some posts claim that G-325R grants lawful status or work authorization. That is incorrect. Registration does not create status, does not grant employment authorization, and does not provide an immigration benefit. The balanced message is this. This rule is important, but not every viewer must submit something new. Many individuals with an I-94, green card, EAD, court document, or other listed record may already have proof. However, some people without any listed proof should not ignore the issue. Before making a decision, pause. Review your documents. Check your child's age. Verify your I-94. Confirm whether your document appears on the proof list. If your situation involves a removal order, a court hearing, a criminal history, prior fraud concerns, an asylum claim, TPS, DACA, VAWA, U visa, T visa, or a family-based case, do not rely only on social media. Immigration rules can change, and this video reflects information available as of June 27, 2026. This video is for general informational purposes only and is not individualized legal advice. Every case depends on specific facts. If you face a deadline, a complex matter, an arrest, a prior immigration violation, or an official notice, consult a qualified immigration attorney or accredited representative. If this information was helpful, like the video, share it with someone who may benefit, and subscribe to Visa and Green Card News for updates. In the comments, let us know which immigration topic you would like us to discuss next. Please do not post receipt numbers, A numbers, passport details, addresses, dates of birth, full legal names, or private case documents in the comments. Protect your records. Verify before filing, and approach each immigration step with calm and careful preparation.